everyone, and welcome to NITI Samvaad by Kautilya Society at NUSRL. Today, we are diving into the topic of PESA Act 1996 as Jharkhand is moving forward to implement PESA rules after 25 years of its formation. I am your host, Asst, and I have with me Assistant Professor Ramchandra Oraon, sir. For our listeners, Sir is a faculty member here at National University of Study and Research in Law, Ranchi. Sir holds an LL.B. degree from the University of Delhi and an LL.M. in Human Rights and Humanitarian Law from Indian Law Institutes, New Delhi. Professor Oraon brings over a decade of diverse experience, including academic teaching, legal research, and fieldwork. He has published extensively in national and international journals, contributed book chapters, and frequently delivers lectures and workshops for government bodies, NGOs, academic institutions alike in issues related to tribal rights, customary law, and PESA. And most importantly, he has been a member of drafting committee of PESA rules in Jharkhand. It's a pleasure to have you here with us, sir. Johar.
Johar to everyone.
So, sir, to start off this episode, to the listeners who might not be familiar with the PESA Act and rules, can you tell us what PESA is all about?
Well, to start with, as the name itself suggests, PESA, that is in short, which means provisions of the Panchayats, extension to the Scheduled Areas Act 1996. So, this is the long name of the Act, but in short or in layman language, we call it PESA, right? That indicates the provisions itself, which is being extended to the scheduled areas, which were not extended to the scheduled areas once the constitution came into being, or for the example, the Panchayat Raj came into being. It was not extended to the scheduled areas because there was an embargo in the constitution in part 9, which said that the parliament will have to enact a specific law, and that was under article 243M, and it said that it will not extend the panchayat to the scheduled areas. If the parliament has to extend it, because it is central law, they have to pass a legislation, and that is under 243M4B. So it says that parliament extends the panchayat system to the scheduled areas because scheduled area is having its own unique status under the constitution. So it is in short called PESA, but it's the provisions of the panchayats enumerated in part 9 of the constitution.
Alright, so you talked about scheduled areas. While researching about the act, our team also came around this specific word, scheduled area. Can you tell us why certain areas are categorized as scheduled? What is the reason?
Right, very, very relevant question you have asked. You see, scheduled area, the concept is, if you see the schedule 5 of the constitution, under part C of that, under article 244(1) of the constitution, scheduled areas means those areas which are designated by the president as scheduled areas. This is what it says. But nowhere in the constitution it gives you as to what is the basis of declaring an area as a scheduled area. Now, in order to know what is a scheduled area, you will have to travel back in history, and without going very, into history, we can trace its official proclamation from the Scheduled Districts Act 1894, right? And that was the time when Britishers, because of the unique situation prevailing then, they understood that there were so much revolts in these areas, which were primarily the tribal dominated areas. Then they segregated these areas from the rest of the country, and they named it as scheduled districts and formulated an act called Scheduled Districts Act. Now what they did is that they made certain areas partially excluded and certain areas as excluded areas. These two terms were used. So one is partially excluded, the other one is wholly excluded. Partially excluded means that they will have some sort of a control, right, where the governor's agent will be supervising that, such as the area now today, which is under the 5th schedule, are the areas which were then denoted as partially excluded. That means they are not fully excluded, they are partially excluded, where the governor general rules through his agent. So there is a control. Whereas wholly excluded, or you can say excluded areas, are those which are now under the 6th schedule, which is your Assam, Meghalaya, Tripura, and Mizoram. So these are your wholly excluded areas. So that was the creation which was done under the Scheduled Districts Act. Now, over a period of time in history, things were carried on as it is. Now, when it came to 1909 Government of India Act, the concept was retained, partially and wholly. In 1919 Government of India Act also, the same thing was retained. When it came to Government of India Act 1935, based on which our present constitution is based, right? So they retained two sections from there. First is 91 and 92. So 91 talked about how the schedule areas to be demarcated. So they retained the same thing, wholly and partially excluded thing. And 92 talks about the power of the governor. The governor is supposed to administer these areas for peace and good governance, right? So when India became free, when India became an independent country, the constitution came into being, and these two provisions, 92, 91, were borrowed in our constitution and were put it under the 5th and the 6th schedule. So now under the 5th schedule, you have a number of states. There are 10 states which have the scheduled areas, right? And there are states which are not so scheduled areas, but they are applicable to the scheduled tribes. Say, for example, West Bengal. West Bengal is a state which does not have a scheduled area.
Yes.
But the 5th schedule provision will apply to them also, because the nomenclature of 5th schedule is that it is a provision to administer and control the scheduled tribes and the scheduled areas. Two things. Whereas it is not the case with 6th schedule. It only says the administration of the tribal areas. So those are the tribal areas, and this is the scheduled area. So there's a demarcation. Now, you see, in the constitution, as I said, this is the historical background. But in the constitution, it does not tell you what is the criteria of determining an area as a scheduled area. In 1960-61, there was a commission constituted called Debar Commission. It submitted its report, and it laid down certain grounds on which you can demarcate an area scheduled area. Earlier, these all areas were sort of a backward areas. Okay, so the first criteria it said is there should be first preponderance of tribal population, right? Then it says that it will be an area which will have its own geography. That means the geographical location would be there, right? That means you can demarcate that area based on geography. Say, for example, if Jharkhand is a scheduled area, that means there are Santhal Pargana, there is Kolhan, there is Chotanagpur Plateau, right? So you can easily demarcate and you see. So first is dominance of tribal population. Second is the geographical division. Third is that the area which is so demarcated should be administratively viable to rule, right? It should be administratively convenient to rule. So that was another. And fourth is that these areas have a marked disparity in terms of economy. It is a economically backward area in comparison to other areas of the country. So these are some of the criteria which were laid down by Debar Commission for scheduled area, which are still, you see, adhered to. So that is how things are later on, you see, translated based on this kind of division. In the constitution, it is not there, but Debar Commission talked about it.
Sir, what I could get is an uncontested fact is these areas have unique needs. They're unique in nature. So a follow-up question would be, what does PESA rules and act have to cater to these unique needs? Can you tell us about that?
Like I said, these are the areas which were in British time excluded areas or partially excluded area. Let's say it is the partially excluded area, we can say, because we are not talking about the 6th schedule. We are talking about the 5th schedule areas where PESA is there. Now you see, since these areas were uniquely placed, why it was so? Because first, there is a preponderance of tribal population, schedule area. Secondly, schedule area is distinct from general areas because here the tribal population is majorly governed by their customs and traditions. Their laws are not written. They are into practice and have acquired a force of law under the constitution, right? So this is one. And by saying that they are enjoying or governing by their own customs and tradition, it means that they have their traditional set of governance. Now, when the country became independent, we came under the one governance system. But these areas were still enjoying or being governed by their own age-old traditional governance system. Now, to acknowledge that, there has to be something. Now, we all know that majority of the tribal population reside in rural areas. Now, in rural areas, the grassroots democracy is through panchayats. We all accepted that, okay, we will have a three-tier model of structure in panchayat, gram at the village level, and then at the block and at the Zilla Parishad level. So, country-wise, every state made their own panchayat laws, but these were restricted from operation in scheduled areas because of the unique position. And now, if they are to be translated, they are to be translated by enacting a particular law, central law, and that is PESA. So, it caters to their needs, their governance model, their control on the resources, etc.
Walk us through some of the more important provisions of the PESA Act.
You see, entire of PESA is important. So, we cannot say that this provision is important than the rest. They are important in their own way, right? But if we broadly classify the provisions, we can say that we can broadly classify it under different heads. First is with respect to the recognition of culture and the customs. So, here if you see, the PESA Act has acknowledged the culture. They have kept the community at the very center of all the governance model. They have emphasized on the cultural identity, customary way of dispute resolution, and even the definition of village, if you can see in the Act, it talks about that the village can be a tola or maybe a group of tola. It is taking into account the geographical unevenness of the scheduled area. So, first is on the culture and custom aspect they have recognized. Second, if you see that this PESA Act also gives you the right to customary way of resource management. So, it is all about resource rights. One is on the cultural aspect, one is on the resource aspect. So, it is talking about your you say customary management of the resources. Resources could be land resources, resources could be with respect to minor water bodies, managing minor water bodies. There it talks about the fishing rights, there it talks about right to collect you say forest produce like minor forest produce, right? Right to regulate some sort of hunting or something, right? Right to manage the market. So, these are all community related rights where a community is enjoying for pretty long time, and that is the right which is given under the PESA. Land rights, forest rights, mineral rights. So, all are community related rights. Then you see with respect to the social sectors also, it is giving you the rights. For example, if there are schemes, then poverty alleviation, as I already mentioned, that if there are schemes with respect to poverty alleviation, then the identification of the beneficiaries are to be done by the Gram Sabha. If there is a scheme which is to be implemented, the UC has to be given, the utilization certificate to be given to the Mukhya by the Gram Sabha. So, it is a bottoms up approach rather than top down approach, right? So, and with respect to management of other things such as Anganwadi or primary health center or fair price shop or village development activities, all in the hands of the Gram Sabha. So, on the social sector also, this also particularly gives you a lot of right? And then also with respect to trade, such as money lending business, to control the money lending business or to control the market, how to control the market in that particular schedule area within that the Gram Sabha, that also gives the power. And it also gives you the power to regulate certain practices such as intoxication, because in the rural areas intoxication is rampant. So, instead of the excise department, the power is now vested in the hands of the Gram Sabha. Gram Sabha can regulate the intoxication there, right? At the same time, the PESA Act talks about the district level administration. This is, PESA is panchayats, related to panchayats in the scheduled area, but it also focuses on the district level administration, how that would be. And Bhuria committee has specifically in its recommendation mentioned that the district level arrangement should also be done as soon as possible. But unfortunately, that has not been done, which is still a concern. So, in nutshell, we can say it gives a lot of power. It gives you power on your customs, culture, your community resources, on sectors, different sectors to control land, alienation, control over the minor minerals, forest rights, and overall, you say, governance.
Sir, I believe that every legislation begins with a vision. So, can you tell us what the lawmakers had in their mind when they were legislating, when they were drafting the PESA rules and act?
Yeah, very important question here, because you see, the parliament made that embargo, that parliament has to enact it, right? And the legislatures, they knew that these areas have specific needs. First is, this is an economic disparity in this region, in the scheduled area. Their governance model is unique in this particular area, right? And the bureaucratic apparatus, whether it be at the colonial time or even after immediately after the independence, had not touched the tribal code, which was realized when Bhuria committee was constituted. I mean, Bhuria committee was constituted in the light of the constitutional provision that is there. So they made a detailed study, and the concept of bringing Panchayati Raj in the country was democratic decentralization. That means to empower the grassroots democracy, right? But to empower the tribal pockets, you have to empower the traditional system and with respect to the customary way of managing the affairs. So to bring a grassroots democracy through panchayats in the scheduled area, you needed a specific act, and this is why this came. So that was the very purpose, how to empower the people who have been disempowered during the colonial and immediately after the independence. That is the very sole purpose, to bring this particular act, and that was the reason that was also in the mind of the legislatures.
So you talked about the Bhuria committee, and I believe if you're talking about PESA Act, we can't skip the contribution of the Bhuria committee led by Dilip Singh Bhuria. So can you tell us about what is the role of the Bhuria committee to our listeners, and what were its major recommendations to the act and rules?
Right. So the Bhuria committee is set up because the constitutional mandates that the parliament is to enact a particular law, the central law, right? So at that point of time, the member of parliament, Shri Dilip Singh Bhuria, he, under his, you see, leadership, a committee is set up, and that is immediately after, once the 73rd constitutional amendment is done, that is 73rd 1992, the amendment comes into force in 1993, right, where the panchayats gets the constitutional recognition. Now, since there is one article which I mentioned, 243M4B, under Part 9, which says the Parliament has to enact a law. Now, in that light of that, the Parliament, if it has to enact a law, it has to do the study first. And that's why Bhuria committee was constituted. Now, Bhuria committee made immense contribution because it is the child of Bhuria committee. We can say if PESA is there today, it is the child of Bhuria committee. Without Bhuria committee, this PESA would not have been there. Now, there are so many members in that. If I talk about Jharkhand specific, you see former commissioner of the Tribal Welfare Commissioner at the national level, late B.D. Sharma. Then you had Bandi Oraon, who was the former IPS. I mean, so many people were there who immensely contributed. And they submitted, after their study, 2 reports. In 1994, it was constituted, and 1995, the report was submitted. Okay, one report relating to the panchayats, that is in the scheduled area, that is what is called PESA, and the other one, they had suggestion with respect to the MESA, which is still not there, although there is a provision in Part 9A, right? So Bhuria committee has an immense contribution because they understood the tribal, you say, self-governance model, and they also studied the sixth schedule part, the administration in the sixth schedule area, and they wanted to give the ownership of the resources to the tribal population, because they have been managing since day one, and it is an recognition to their you say culture, their identity, their way of dispute resolution, for the grassroots democracy to be empowered. They have to be given that particular power. They have, because it was for the very first time that this system, constitutional, is actually acknowledging the system, their system, tribal governance model. So it has an immense contribution to make.
Indeed, sir. So, if we look at PESA rules, implementing them in Jharkhand would be quite special because, first of all, it's new.
Right.
But I would like for you to explain to us how would the PESA rules differ from rules that are already in place in Jharkhand, like JPRA of 2001,
Right.
and how PESA rules would impact the people, daily lives of the people for which it is being implemented.
You see, with respect to Jharkhand, Jharkhand is a unique state in that regard, if I say.
Indeed, sir.
Because you see, it came into existence in the year 2000. Right, from Bihar, and this PESA got enacted in 1996, right? It came into being, and then it said that whatever laws which are in existence before, that means the enactment of PESA by the state legislature, if they are inconsistent with, they are not inconsistent with PESA, they will after a year automatically come to an end, or before the expiration, or they will run, the laws will run to the extent till they expire, I mean till the expiration, unless the state legislature amends or repeals that. Okay, so after 1 year, those provisions which are with respect to panchayats which are there in the state will come to an end automatically. This is what the PESA talks about. Now, 1996, it was enacted. It received a presidential assent, 24th of, to be precise, 24th of December 1996. So by 24th of December 1997, 1 year, and later on, in 1997 onwards, December onwards, your laws which are not inconsistent will automatically expire. Now here you see, thereafter Jharkhand is formed. Now immediately after Jharkhand is formed, you already had Bihar Panchayati Raj. So this state did not take the Bihar Panchayati Raj model, which other state took. For example, Chhattisgarh took, and they took the what is there in Madhya Pradesh, and they accordingly they followed it even till today, right? But Jharkhand enacted a new law, state law, that is State Panchayat Raj Act, that is Jharkhand Panchayati Raj Act in 2001. Now, once this was enacted in 2001, the litigations also came up. The first litigation started way back in 1994 itself, but if we, after coming of PESA 1996, when JPRA was formed, they, because there was a specific instruction that you have to incorporate your PESA provisions into the state law, because they cannot be against it. So some of the provisions of PESA were taken into JPRA. For example, the PESA talked about that in the schedule area there will be 100% of reservation of the chairperson post at all levels, at all three levels, right? The village level, it would be the Mukhia. At the block level, it would be the block pramukh, and at the Jila Parishad, the Jila Parishad chairperson, Adhyaksh, will be all scheduled tribe. Now it was contested in the court. So those provisions, some of those, we will talk about it, what was the contest and all, but answering to your question, that some of the provisions were included in JPRA, right? This is one, it was included. Secondly, if you say, on the softer side, that is, the villages will be governed by their own traditions, own customs, there will be dispute resolution as per the softer side. They were all acknowledged and taken into JPRA. But on other side, such as the ownership part on, you say, minor minerals or prior permission of Gram Sabha with respect to obtaining minor mineral licenses, etc., were not taken, which related to the revenue part, I mean, which was the main contention that the people wanted. Those were not taken. So you see, despite JPRA being in place, there were number of provisions which were not taken. So it was not a complete inclusion of all the provisions of PESA, and that became a bone of contention even till today. So although JPRA is there, then you see 2001 it came, litigations followed, and litigation went up till 2010. Okay, so there was a lot of political instability in the state. There was no majority government in the state. So there was a political turmoil in the state also. And Panchayat elections were also did not happen because there was a case of Rakesh Kumar versus Union of India, which was instituted challenging the provisions of 100% reservation, which was included in JPRA. So that case dragged in for a decade or so, until such time when the Supreme Court finally gave its order that the provisions included in JPRA is constitutionally valid. And then in 2011, we had the first Panchayat election in the state. So you see, although we have so many things, but not every provisions are there in JPRA, and definitely there is no rule.
Sir, while we are on contentions, I believe we should also address one of the major concerns in implementation of PESA, that is land alienation.
Right.
So, sir, can you tell us about what is this concern exactly about, and does PESA have some provisions to cater to this concern?
Yes, of course. You have asked a very important question. Let me just bring out what the law says, right? It is saying under Section 4M, precisely Clause 3, it talks about the power to prevent alienation of land in scheduled areas and to take appropriate action to restore any unlawfully alienated land of a scheduled tribe. So, PESA has a specific provision, and land alienation is a very big concern in the state, or for that matter everywhere in the scheduled area, because you see, wherever you have a scheduled area, you have special protective laws with respect to land, right? So till such time when PESA was not there, we already had Chota Nagpur Tenancy Act. We still have Chota Nagpur Tenancy Act. But in Chota Nagpur Tenancy Act, if you see, the power is vesting with the Deputy Commissioner. It is not with the Gram Sabha. But now, it is for the very first time the Gram Sabha has been given this power to restore the land which has been unlawfully alienated, and to also to prevent land alienation. It's a very big shift, where you are giving the power to the Gram Sabha to decide for themselves without relying on the authority. They are the ones to.
Sir, to add to it, can you explain to us what exactly is land alienation for our listeners?
Yeah, you see, there are many ways by which land is alienated, right? Well, you know that this area is a scheduled area, and the issues of land have always been there. And if you see, the land alienation is not specific to this age and time only. Ever since this area has been in existence, whether it be in the time of the kings or the queens, or of the times the Mughals, or times the British, or even today, land alienation has been there. But it would be long if I go back into history, right? But to precisely answer your question, today, the land alienation, because under the CNT you have a specific provision which talks about that the scheduled area can only transfer the land to another scheduled area who is residing in the same limit of the police station where the land is situated. He cannot transfer to the non-tribal, right? And if he does so, it is in violation of CNT section 46. Okay, and then if it is in violation of that, it will not be registered under any civil, revenue, or criminal code. Right? It is non-registerable. So now what is the problem? I mean, this is the law under CNT, right? But still you see the land is getting alienated in the name of Sada Patta, that is on plain paper, which has no legal validity, no legal validity, right? And this is one way by which land is getting alienated. And second is there are other provisions by which land had been alienated, but their limitation period has expired. Now there are different courts which are supposed to, you see, restore those lands also. Like for example, schedule area regulation court is there. Some orders have been given, but the land is still not, you say given or done. There's another way by which the provision itself talks about that if you are making a compensation of that particular land, and the deputy commissioner finds that the compensation is adequate, if there is a land which has been transferred, then out of the compensation you can get the land regularized. All those provisions have been used against the tribes, and tribes have lost the land over a period of time. Successful chunk of land have been lost. So these are ways, but for the very first time, the Gram Sabha now has the power to restore that land, which was never in any law. So in that case, this is a unique law.
Sir, how do you think Gram Sabha having the power to solve this land alienation matter would be different from when a deputy commissioner has that power? How will it be beneficial to the tribes?
Yeah, you see, as I said, this particular law gives the recognition to their customs and traditions, right? And we know that in the tribal system, the land is very sacred, and it is not to be primarily sold and purchased. Today, now we have entered into a market system. Market forces were not there in tribals. What was existence in barter system of exchange, right? So now we are all subject to market. And tribal is no exception. Now what is there? Still they have an attachment to the land. One is the land which, yes, with due permission they can sell and purchase with the passage of time. There is another category of land which is specific to their culture and customs. That is the service land. And there have been laws which have exempted them from paying rent on those lands. For example, your Pahanai land. For example, your certain class of Bhunyari land, right? For example, Mundari Khudkati land. In this part of area we are talking. So they have been exempted from payment of land revenue, and they are the unique land in themselves. Now, PESA, the CNT already had this provision, but it made Deputy Commissioner powerful because he is the deciding authority. Grassroots democracy was not there. Deputy Commissioner was all in all under the CNT, right? He is by default a party in all the cases which involves tribal and non-tribal. But Gram Sabha was not there in the picture. Now Gram Sabha, because the PESA has their customary laws have been given that recognition, and these laws are land laws are part of their custom, which they have been. That is how they have been regulating, right? And one thing is also given that the PESA empowers the Gram Sabha to solve their matters, or you say there is a dispute resolution power which is given to them. So they can amicably solve their own disputes. So if it is a matter related to land or a customary land, they need not have to go to the Deputy Commissioner. So they can amicably solve their matter because that is a customary land. So now with the coming of PESA, they have been empowered. Although they were running their governance, but it did not have the protective ambit of the law. Now they have a protective cover of the law that under PESA you can manage your resources as you were managing and can solve your dispute. So dispute resolution mechanism is also inbuilt there, whether it be land, whether it be for other matters also, which normally would go to the courts, but they can out of their own solve those issues.
Exactly. So if we compare Jharkhand to other states, we are relatively young. It's only been 25 years of our formation. However, I still believe it's a relatively long time to implement the PESA rules. So can you tell us what has been obstacles in the way of the Jharkhand government as to why these rules haven't been implemented till now?
Yeah, it has been really very long. It has been almost 28 years.
Thanks.
And there is no rule. And we are one of the two states who have not made the rules, one being Orissa. And our other states like Chhattisgarh, which got formed on the same year, now has a rule. Yes, you are very right, because Jharkhand's, as I said, you see, entire political scenario was different from the other states, right? There had never been a political stability for more than a decade or so. And the litigations also went in. So in that respect, it had its own challenge. As I talked about, there are a number of factors. The first is, you can say there has been no political stability in the government, right? Second would be that there has been litigation ever since the enactment of PESA Act, and precisely after its inclusion in JPRA in 2001. So some provisions were included in that. So what happened is that took a lot of time for us. The reservation part I'm talking about, where Section 4H talked about, and it was challenged in the court of law. In Jharkhand High Court, it was challenged, and then it was clubbed with several other cases, and it was heard by Jharkhand High Court, and Jharkhand High Court rendered its judgment saying that, you see, this is unconstitutional. JPRA is unconstitutional, especially this provision. But when the matter was heard in an appeal in the Supreme Court, relying upon the, you see, recommendation of Bhuria committee, if you look in the judgment, it will give you the paragraph of the Bhuria committee as to why there should be 100% reservation. It said that it is not unconstitutional. The provisions of reservation is constitutional, because this is not the reservation which we are talking about, admission to colleges or admission to schools or employment. It is a reservation on a social scale. Although there has been a demographic decline, but there is no denying from the fact that this area has been predominantly a tribal area or a scheduled area. Others have migrated it. Now today the demography had declined. That does not take away the benefits of being a scheduled area, and which is there in the Bhuria committee recommendation. And taking that into account, what was declared unconstitutional by Jharkhand High Court was declared as constitutional. And that, but it was a win-win situation, but it took 10 years of Jharkhand's time. And that, that you can say that Jharkhand was without any Panchayat election, and the grassroots democracy suffered for a decade after its formation. Okay, that is one major, you say, bottleneck in our making the rules, because we cannot make a rule if the matter is sub judice. Third, now that Supreme Court has given, now 2011 the elections were completed. Now even after that also, today we are in 2025. So almost 15 years have been passed, still we have no rules. Yes, we have Panchayat elections that was conducted, three Panchayat elections have been conducted, and based on that, PESA provisions are finding its place in the Panchayats, right? But now, despite these many years, there were attempts to make rules, because Act is already there and Act is also in operation, but there is no specific rule. And there have been attempts to make rules, but there have been a lot of confusion prevailing in Jharkhand, for example, which is coming on the way of making the rule. There is a lot of confusion among the public, and there is a cynicism prevailing that if the PESA rules comes into being, although it talks about customary law and traditions, etc., there is a feeling in some segment of the public that it will take over the traditional governance, or there is a feeling that it is nothing but the Panchayat Act is being thrust on the scheduled areas without making specific changes related to their area accordance to PESA. So this is a wide confusion prevailing. So some say that it is the Panchayat Act which is being thrust on them. Some say that the Panchayat Act is unconstitutional. So some say it is not PESA, it is PESA. So after all, the nomenclature starts with provisions. So if you say that PESA, that is also not wrong. But in short, it's called PESA. So all those things have confused the public. And not only that, it has also confused the legislatures. And because there's a confusion in the minds of the people, things are not streamlined. And that has caused a lot of delay. And even the delay today is because of all these misinterpretations happening, which is coming on the way to enact the PESA rule, although there has been a draft being placed before the government. Yeah.
So now, since after 25 years, we are actually going to implement the said rules, are there any steps that you would like to suggest the government to implement the said rules effectively so that it, it is effective at the ground level?
Yeah, we cannot say we are going to implement the rule because the rules are yet to be enacted. So we can say that we are in the process of making the rules, yes. And the rules have to a certain extent have been tried to be in consonance with PESA, right? And all the provisions of PESA should be incorporated. That has been an effort which has been made by the discussions which have been conducted by the state authorities. Okay. Now you see, as I said that in JPRA there were not, all the provisions were not included. Softer provisions were included. But now, because we are making a rule, all sort of provisions have to be there, right? So now the present rule is trying to bring all those provisions which are untouched. For example, the restoration of land, which was not there in JPRA, it is there in the rule. For example, the command over or the control of the resources of the Gram Sabha, which was not there, which is now in the rule. For example, control of money lending, how to control money lending in the scheduled areas, those are there in the rule, right? Because money lending has been one of the way of exploitation. Then you see ownership right with respect to minor forest produce, which was only added in 2007 in JPRA. That is also now brought in the rules. Your use, access and dispose rights of minor forest produce, because it's giving you rights from that. Then with respect to minor minerals, your reconnaissance license if you are granting minor mineral license, you ought to have a consultation with Gram Sabha. Those are mandatory now under the rule, which was not there in JPRA, right? And control over the social sectors. For example, if there is some beneficial schemes which are there in the grassroots level in the Gram Sabha, then or let's say there is poverty alleviation schemes which are coming up, then the task is given to the Gram Sabha to identify the beneficiaries. So that is there. And also they also have the control on other social sectors. For example, schools, managing schools, primary health care center, right? Any particular scheme which is there coming in the village, they have a control over that scheme, because now the Gram Sabha is supposed to give the utilization certificate to any government schemes which is coming through the Panchayats. So that was not there. So all these things are, you say, included, have to be included because they are part of the PESA Act. They cannot be inconsistent with the Act. So they have to be included, and the rules have been made in that direction. Although there have been certain lacunas, for example, section 4.0, which talks about the administrative arrangement in the district level. The PESA says that your administrative arrangement should be on the pattern of the 6th schedule, where there is a pattern of autonomous district council and regional council. Now that is not there here. There have been also case with regard to this, and that case was PNS Surin case. Unfortunately, it was lost in Supreme Court. Supreme Court did not give the favorable decision, but there was a case. So now you see all these provisions are there, but barring section 4.0, rest of the things are in the draft rules. Okay, so that is in process now.
Thank you, sir. This has been an incredibly insightful discussion with you. To wrap things up for our listeners, can you tell them one key feature that you would want them to take away about Jharkhand and its relation with the PESA Rules and Act?
I could say that Jharkhand is a unique state in its own, and it is a model state, I could say, for implementation of PESA for other states. Even in the discussion which the state government had recently, it was reiterated that Jharkhand is enacting such a rule which may be a forerunner for other states to follow, right? And this is a state where all the ingredients which are mentioned under the PESA Act can be seen here. We have 32 tribes, and there are tribes which have their own system of governance, and they are managing the resources as mentioned under the PESA. And this is one of the states where you say the PESA can actually bring the grassroots level democracy, to its realization. So one last takeaway is that the rule of PESA will actually help in bringing the democratic decentralization in the scheduled areas if properly implemented.
Neat, sir. Thank you so much for sharing your expertise with us today, sir. It's been a pleasure hosting you for this episode of our podcast. And to our listeners, thank you for tuning in. Please don't forget to check out our last podcast about PESA, and tune in for our future endeavors where we come back with a new policy or a new legislation. Johar.
Yeah.